What is the structure of the federal judiciary? A key feature of the American legal landscape is its dual court system. This means we have two distinct court systems operating side by side, the federal court system and the court systems of each individual state. In the state court systems, we'll get into states just a little bit here. Most legal disputes in the U.S. are handled at the state level. Each state has its own system, typically mirroring the federal structure with trial courts, often called superior courts, district courts, or courts of common pleas, intermediate appellate courts, and the state supreme courts. These courts have jurisdiction over cases arising under state law, including most criminal cases, murder, theft, assault, under state codes, contract disputes, family law, divorce, child custody, personal injury lawsuits, etc. State judges are selected through various methods, including election, appointment, or hybrid merit selection systems, depending on the state. In the federal court system, established under Article 3 of the Constitution, this system handles cases involving federal law, the U.S. Constitution, or specific parties. Judicial jurisdiction is limited. Cases typically enter the federal system if they involve a federal question, interpretation of the Constitution, or a federal statute. The U.S. government as a party, either instigating the lawsuit or on the receiving end of the lawsuit, disputes between the states, disputes between citizens of different states, diversity jurisdiction, usually involving significant monetary amounts, and then matters like bankruptcy, patent law, maritime law, other aspects of the law that transcend state law. The structure of the federal judiciary is hierarchical. The U.S. district courts. There are 94 federal trial courts where cases originate. They have original jurisdiction in federal matters. Evidence is presented, witnesses testify, and juries often decide the facts of the case. There are also U.S. district courts of appeals. If a party loses in one of those district courts and believes that legal error occurred, they can appeal to the appropriate circuit court. There are 13 of these circuits, 11 regional. There's the D.C. Circuit and the Federal Circuit with specialized nationwide jurisdiction. These courts review the lower court's application of the law, typically with a panel of 3 judges. They don't try to retry any facts. Because the Supreme Court hears so few cases, the circuit courts are often the final arbiters of federal law within their region. Normally doesn't get beyond that. Finally, the highest court in the federal system and the ultimate interpreter of the Constitution is the U.S. Supreme Court. It has original jurisdiction, disputes between the states, but its primary role is appellate, reviewing decisions from federal circuit courts and occasionally state supreme courts if a federal question is involved. So at the federal level, 94-13-1 to the Supreme Court. This dual system reflects federalism, the principle allowing states autonomy over their laws while ensuring uniformity in the interpretation of federal law and the Constitution nationwide.